and participants. In the nearly 33 years since Dana Ireland was kidnapped, raped, and killed, the Hawaii Police Department has remained resolute in investigating this case and following that evidence wherever it might lead. We remain committed to solving this case and helping bring closure both to the Ireland family and to the Big Island community. Earlier this year, an FBI agent from the Honolulu field office contacted our police investigators with the names of some people who could potentially be identified as unknown male number one. One of the names provided was that of 57-year-old Albert Lauro Jr. Lauro Jr. lived in the Kapoho area, which is the scene of the Ireland murder, at the time of the murder. In the weeks since, investigators collected a utensil that Lauro Jr. had been using after he discarded it, and the DNA from that utensil was analyzed and found to be a match to unknown male number one. Tragically, Lauro died on July 23rd. So there has been significant reporting. There's been some filings for a case that's coming up on Tuesday. And there have been three main issues that have been brought up through that reporting and through that filing that I wanted to address before I take any questions. The first question is, why didn't we arrest Laurel on July 19th? So in the time after we preliminarily identified Laurel and we got the preliminary DNA match that listed him as unidentified male number one, we were forced, as we always are in any criminal investigation, to do some analysis. That analysis started with determining what crimes or what categories of crimes had been committed. In this case, we had a murder, we had a sexual assault, which was called rape in the 1990s, and we had a kidnapping case. Unfortunately, in the 32 and a half years that have transpired since Christmas Eve 1991, the statute of limitations has run out for the sexual assault or rape case. The only statute of limitations that remains in effect currently is that for the murder case. So when the question is, why didn't we arrest Laurel on July 19th when we invited him in for a consensual encounter? The answer is, the evidence that we had at the time certainly would have indicated to us that he had a sexual encounter with the victim on or around the time of her murder. That's pretty reasonable. But aside from that, we felt, and we continue to feel, that there was not probable cause at that time, based on what we knew, that Laurel committed the offense of murder, which is the only charge we had left to investigate. In order to arrest someone or charge them or convict them of murder, we have to be able to prove beyond a reasonable doubt that the person's conduct was intentional or knowing and that they caused the death of another person. So of those elements, the death of another person is clear. Dana Ireland died nearly 33 years ago. But we felt then, and we continue to feel, that the presence of Laurel's DNA at the crime scene was in and of itself not sufficient evidence to prove that Laurel intentionally or knowingly caused her death. We feel that this is definitely an important part of the investigation, and most of the best information that we had planned to get in the course of this search for the truth, we at that point believed would have come from Mr. Laurel. So when we invited him in for a consensual encounter, we sat down, we talked to him for about an hour, and at the end of about the hour, we collected a court-ordered DNA sample to compare against the exemplars that we already had. And Mr. Lauro indicated that he wanted to leave. So at that point, we have to make a choice. We're either going to arrest Mr. Lauro based on what we know, or we're not going to arrest him. We made the decision not to arrest him because, as I said, the evidence was not sufficient, in our opinion, to prove that he intentionally or knowingly caused Dana Ireland's death. That doesn't mean that's the end of the story. There are a lot of other investigative avenues, techniques, search warrants that we have been working on, that we plan to continue working on. In fact, just this afternoon, in the last 2 hours, we were finally able to use technology to get into Mr. Lauro's cell phone. So we hope that there are some answers in there. We hope that there are answers in his friends and family members who either knew him recently or around the time of the murders that can help guide us to the search for what really happened. The second question I want to address is, what would have happened if Lauro had been arrested on or around July 19th when we brought him in for a consensual interview? Would he still be alive today? So the answer to that, again, is a little bit complicated. we have to take a look at what would have happened if we had made an arrest without probable cause. As any good attorney, defense attorney, or prosecutor or police officer will tell you, if you make an arrest without probable cause, anything that follows that arrest, whether it be a confession or physical evidence or the identity of another witness, anything that arises out of that arrest is going to be challenged based on what we knew during the arrest. So we face the very real possibility that if we had arrested Mr. Laurel without probable cause, that anything we gathered as a result of that process could be excluded, which is absolutely not what we wanted. The other thing to consider is this. If we had made the decision to arrest Mr. Laurel on July 19th, then his name, his identity would have been made public several days before he ultimately decided to commit suicide. I can't imagine, if he had been arrested, that within 48 hours, as required by Hawaii Revised Statute, that the prosecutor's office or any state agency would have authorized us levying a charge, which means that within 48 hours, Mr. Lauro would have been released. And all of you would have been standing at his driveway to welcome him home. Because it's a story, right? It's important. So there were parts and there were pieces of the investigation that we held close to the vest. But we did that on purpose. As I mentioned, what I feel would have been the best evidence in this case would have come from Mr. Laurel. Unfortunately, we're not in a situation where we can get that from him now. So the journey continues. And then the last question that I want to address is what happens now? Now that Albert Lauro Jr. is died, does that mean it's the end of the road? And the answer is absolutely not. We remain committed, as we have since day one, of solving this case, to follow the evidence, the physical evidence, the testimonial evidence, the eyewitness testimony, as far as we can. Wherever that path leads us, that's where we're going. Because ultimately, it's our responsibility to provide justice for the victim, Dana Ireland in this case, and closure to her family and the citizens of the Big Island. At this point, the investigation is continuing, and our search for the truth is absolutely not over. We've taken an opportunity to share photos of Mr. Laurel, both recent and time period, approximately 3 or 4 years before the murder. And we would ask that if people in the community knew Mr. Laurel or know of any involvement he may have had in this case, to please contact us. Contact Captain Rio Eamon Wilkins at 961-2251 or by email. And all of his contact information is in the press release published on our website, hawaiipolice.com. And with that, Ms. Leighton, are there any questions from our online participants?
So for those journalists participating online, does anybody have any questions? We'll start with our Zoom participants first. Just unmute yourself, type it in the chat. Please identify. Dan, can you please say your media outlet, please? And does anybody, so Dan Nakaso from Honolulu Star Advertiser is asking, please describe how Laurel killed himself and whether he left a note.
So it's a little bit weird. In the county of Hawaii, as well as Kauai and Maui, the police chief wears 2 hats. Well, actually several hats, but 2 hats according to statute. One is as the police chief, the other is as the coroner. So we're investigating Mr. Laurel's death as a coroner's inquest, similar to how a medical examiner, for instance, in Honolulu might examine a similar case. Because of that, I'm not yet ready to talk about the manner of Mr. Laurel's death, besides to say we do believe that he killed himself. And I'm sorry, what was the rest of the question?
Did he leave a suicide note?
Did he leave a suicide note? So that's definitely part of what we are still trying to find. There wasn't anything really obvious at the scene, but that being said, we're not done. We're not done talking to his loved ones. We're not done, again, as I mentioned earlier in the press conference, within the last hour or two, we finally got into his phone that we collected as part of that coroner's inquest. So we hope that there's information that helps us to understand why he made the choice that he did.
We have a question from John Burnett, Hawaii Tribune Herald. John, what's your question?
I guess I'll unmute because I'm better at that than I am typing. My question is the motion that was filed by the Hawaii Innocence Project basically says that it doesn't trust the Hawaii Police Department and believes that that you at this point are still espousing a 4-killer FOUR, that is, killer theory, and following that as part of your investigation as to whether unknown male number one acted alone or if he was one with the three who had been convicted of the murder. Is that accurate?
John Burnett of the Hawaii Tribune Herald is asking if we are still espousing a four suspect theory in terms of this investigation.
So the answer to that is we don't know yet. Certainly at this point, all things are possible. We wish we had been able to get that information from Mr. Laurel. At this point, we haven't been able to. It's something that we're investigating, certainly, as a possibility. And at this point, any questions or comments about the convictions of the other three defendants, I would refer you to the prosecutor's office as far as what their actions and decisions are going to be. Essentially, what this update provides us, what's happened in the last 3 weeks, identifies a person who had previously been unidentified, right? So that's, for us, that's the big thing. We now have a whole plethora of new avenues of investigation that we can pursue. We can talk to people who knew Laurel at the time. We can look at motor vehicle registration records. We can try to get into his phone. If that gives us enough information to file a search warrant that can search something else for something else, those are all possibilities in all directions that we're willing to go. We're going to follow the evidence in this case without predisposition, without any belief that what we know or don't know is right or wrong. We're going to follow the evidence to wherever it leads, and then hopefully have a chance to share that information back with you folks in the media and the public as soon as we can.
Okay, one more question on our Zoom, and then we'll take questions in the room. Madeline Valera with Civil Beat is asking, can you share some of what Lauro said during the meeting police had with him on July 19th?
So we did talk to him for about an hour. That included the conversation with the detective and the process of obtaining the buccal swab. The conversation, as with all, I saw this reported earlier today, an allegation that we didn't record the conversation. Every conversation with a suspect or a potential suspect in a criminal case is recorded. That's, to do anything less would be malpractice. So we conducted a recorded conversation. I'm not quite ready to discuss the contents of that conversation, aside from to say that we did get some information that leads us down different investigative paths that we're trying to figure out where those paths lead, and also to say that nothing from that conversation gave us any additional evidence that we could use as probable cause to arrest Laurel at the end of the interview.
Okay, we'll take questions in the room if anybody has any questions, and then we'll get back. If anybody has additional questions on the Zoom chat, just put them in the chat. Any questions in the room?
How is this being investigated at this time? Are you looking back to the 1991 scene? Were there DNA on the fingernail, stuff like that? Is there anything that you can give us as far as details about how the present and past are being connected?
Sure. And so a lot of this is in the press release, but at the time of the murder on Christmas Eve in 1991, investigators investigated basically two scenes. There was one scene where it appeared that Miss Ireland had been struck by a car on the bicycle, and then a second scene where Miss Ireland was later located and then transported off to the hospital. So we have evidence that was collected 32 and a half years ago from both of those scenes. There is DNA, and there was always, at the time of the arrest and the trial for the other suspects in this case, the knowledge that this DNA from a fourth person was common knowledge. It was presented, I believe, at trial. The prosecutors knew about it. The defense attorneys knew about it. What's changed in the last 32 and a half years is the technology advance. So we can now take some of that DNA evidence, which in about 2007 or 2008, the department, along with the Office of Prosecuting Attorney, entered into a partnership with the Hawaii Innocence Project as part of their conviction integrity program, where we sent the physical evidence that we had in that case with those DNA samples off to the lab in California, which is where the evidence remains to this day. And so when we talk about comparing current samples against those samples, that's the same lab is doing that was contracted by Hawaii Innocence Project 15 or so years ago. So with that evidence being at the lab and with technology advancing, One of the things that has developed since the original trial was a DNA from the T-shirt. So there was a T-shirt left at scene number 2 that had Miss Ireland's blood on it, and also had what was later discovered to be DNA. So the DNA is, I guess it's described as like residual or habitual wearer DNA. So if you wear your clothes on and off, you leave traces, small traces of DNA, which the technology in the 90s may not have been able to discover or to replicate or build into a profile. So Laurel's DNA was discovered on the T-shirt, that he was the habitual wearer of the T-shirt. And then also we knew from when that habitual DNA came about several years ago that that profile matched the semen samples that were found as well. So we knew we were looking for one person that had the habitual wearer DNA on the T-shirt and also contributed the 2 semen samples at the scene, because those 3 matched together. So what's happened in the meantime is the Innocence Project in probably mid or early 2023, after Albert Schweitzer's guilty verdict was overturned and the case was dismissed without prejudice, the Innocence Project started looking at the potential to use ancestral type DNA. So that kicked off a process where a group that was consulting with the Innocence Project started this ancestral DNA process. At the same time, we had asked an FBI agent in Honolulu to do the same thing. So earlier this year is when we got those names back. Essentially what they do is they look at certain markers in the DNA. They look at ethnicity, race, and they compare those markers to other people in the population, and they can determine, for instance, what percentage of your ancestors are of Filipino ancestry, right? Where you might have a brother or a sibling or a cousin because a certain percentage of the DNA matches. So they take all those clues and they build basically a family tree, a potential family tree of the suspect, and then once they identify who's in the middle of that family tree, then they give us those names as leads. So we were provided with a few names. I think there were about a half dozen names in total. We chose to focus specifically on Mr. Lauro because he seemed to us to be the best of those names. For instance, one of the names was of a previously convicted felon. Well, a previously convicted felon, their DNA would be in CODIS, and that would have matched. So that makes it very unlikely that it's that person. Whereas Mr. Laurel had lived in Hawaii his whole life. Our search of records found that he lived in the Kapoho area around the time of the murder, and that he still lived in Hawaii. So that made his name a good place for us to start on the list. And then, as I mentioned, that led to the surreptitious collection of the sample, which led to the match, which led us to where we are today. So it's very much the DNA that was collected in the 90s, even though the technology didn't exist yet to link it back to Mr. Laurel. The technology change and that partnership with Hawaii Innocence Project has allowed us to now identify him and take the investigation forward.
You mentioned that sexual assault or rape, the statute of limitations have expired, but is that in itself probable cause for the next thing? If you are able to prove the one thing, isn't that grounds to get to the next?
You'd have to ask a lawyer, but the short answer from my perspective as a police officer, as an investigator, is no. That certainly may be probable cause that Mr. Laurel committed a rape or a sexual assault. But it's not necessarily evidence of his intent or his knowing state of mind that he would have caused her death. That he was there, certainly, and that's why we brought him in. That's why we had a conversation with him. That's why we had hoped that after he left, that he would continue to be cooperative, that he would continue to communicate with us, and that we could get to that information, which in our mind was the best source of information, was his recollection of what happened.
Was he being surveilled?
Jeremy, let's get some other questions
Okay.
before we do any more
Sure.
follow-ups. Anybody have any more questions?
Could you address the breadth and scope of the warrant that was issued to compel the sample? And was this gentleman given a time frame in his talk with you about when the results would be coming back?
And Daryl, can you please identify yourself and your
They're
media
all
outlet?
I'm shooting for Hawaii News Now.
Thanks, Daryl. So the breadth and scope of the order to compel was just to compel him to submit a buccal swab. So a buccal swab is like a Q-tip, and it's got a little plastic container around it. We take the Q-tip, we unseal it, we rub it in the inside of the subject's mouth, and we seal it up. And now we know that the DNA that's on that Q-tip came from this particular person because we saw it happen. Then that buccal swab can be sent off and compared against known exemplars. So the extent of the order that we enforced in this case was for Mr. Laurel to submit to that buccal swab, which he did.
Any other?
Was there more to it? I'm sorry. I know there was.
And was he made aware, or did he ask about how long it would take to get the results back?
I think without disclosing what specifically was said in the interview, it was our investigators' opinion that the buccal swab be tested and verified or not as quickly as possible. So we actually paid an exorbitant amount for a rush analysis, and we were able to get the results on Wednesday. We didn't even expect the results on Wednesday. We didn't expect the results till later in the week or the following week. So I don't know that Mr. Lauro was provided with a timeline, because it actually came back a lot quicker than we thought that it would.
And with confirmation in the testing, would you have gone to the grand jury for an indictment?
So that's certainly a possibility, right? As with any criminal investigation, as we discover evidence, as we kind of try to figure out, make sense of that evidence, as we figure out where it fits into our theory of the crime, we take that in chunks periodically to the prosecutors, right? And typically we write up reports, and the reports go to the prosecutors, they review it, and that's their decision. So the decision on whether or not to attempt to indict Mr. Lauro or not would have been made by the prosecutor's office after we disclosed the evidence of what we had found to them. So in this case, because things happened so quickly, I'm not even sure that they knew all the things that were released to the media. I know I certainly didn't at some times. There was certainly some information in this case that was being released either by individuals or groups, I don't know who, that have thwarted our efforts to kind of control our interaction with Mr. Laurel, and to prolong it, and to get a couple shots at talking to him or developing additional evidence. So it's a little bit frustrating in that regard, but I hope that answers your question.
And we have a question from KJN too.
So did Laurel, when he was here on July 19th, confess to kidnapping, murder, or sexual assault?
So again, not to repeat the answer I gave before, but maybe a little different way. I'm not ready to discuss what he disclosed. He did give us some information about what he did or did not remember, and we're trying to fact check that to determine if that we can gain any new investigative leads from the information that was discussed. At the same time, he did not disclose anything that we felt added to that probable cause threshold. That's kind of the only way I can say it without saying what I just told you I didn't want to say. So I'm sorry.
Do we have any other questions in the room? Because I do have additional questions on Zoom. No? Okay. So Star Advertiser is asking, can you provide details on how the fork was identified and collected that confirmed his link to the DNA, and how long he was under surveillance?
I'm not sure how long he was under surveillance before we collected the utensil, which was a fork, I believe. Essentially, we followed him to a public place where he purchased a plate lunch. We watched him eat the plate lunch. We watched him put the fork back in the box and discard it. So evidence like that that's discarded, clearly there's no intention of any type of expectation of privacy. So we're able to collect that evidence from the trash can, seal it off, and send it off to the lab for analysis.
We do have a question from Associated Press. Audrey, what is your question, please?
Yes, thank you. My question is, so the Innocence Project lawyers say police intentionally botched the case to prevent the Schweitzer brothers from clearing their names. I'm wondering if you have any response to that.
I'm sorry, did you just ask if, you're on a Zoom and you're on a speaker a few feet away. Did you just ask if we intentionally botched the case so that the Schweitzers would not be confirmed innocent? Is that your question?
Yeah, that's what the Innocence Project attorneys are alleging, and so I'm wondering if you have any response to that claim.
I understand your question. That is abjectly false. 100% not true. As I said at the beginning, and as I will reiterate, our intent is to follow the evidence wherever it goes. Whether or not the Schweitzers or Mr. Pauline posthumously are determined by the court to be innocent or have their cases dismissed is between the prosecutor's office, their individual attorneys and the judge. That's not something that we're involved in at this point.
We
Thank
have thank you, Audrey. We have a question from Civil Beat from Madeline. Has his home, vehicles, or other property been searched?
So the answer is not really. Certainly when we were sent as part of the coroner's inquest, there was a cursory search of the area around where Mr. Lauro was found. That's what we would do at any coroner's inquest. That having been said, in order for us to obtain a search warrant to go back and search his home or his home that he shares with his family, it's not just his home or his vehicle, we have to be able to say in the warrant exactly what it is we're looking for. And at this point, in this particular case, there wasn't a murder weapon. So for instance, we can't say in there we're looking for a firearm because we don't believe a firearm was used. So we're stuck in a bit of a position where it's going to be very difficult for us to explain, at least as of July 19th, what it is we're looking for, what evidence specifically we might be looking for. Because without that specification, no judge is going to sign a warrant to let people go on a fishing expedition to search for whatever we might be able to find. Now, all that being said, as I mentioned, in the last few hours, we're into Mr. Lauro's phone. The investigation has continued. We've interviewed other witnesses. So is it impossible that we would get to a point where we might have some evidence that we know to go look for? Absolutely not impossible. I, in fact, hope that that's the case. But at this point, based on what I understand, we're not there yet.
We have one more question on Zoom. We are coming up on the half-hour mark, and we do want to wrap this up because we know you have 5 o'clock newscast to get ready for. Did anybody else in the room have questions?
I just have one.
Okay, Jeremy, and then we'll come back to our Zoom participants, and we have 2 more questions on Zoom.
Was the manner of death in 1991 determined for denial, and how does that affect what you're looking for?
My understanding is that the cause of death and the manner of death was homicide. I haven't seen the death certificate. That's a little bit further into the weeds. The investigators might be able to answer that. Perhaps we can get back to you on that particular question. That's not something that I know. I'm sorry.
Yeah, I'm looking into if it's the car, if it's, anything
I
else,
see.
but-
Okay, we can definitely find that out for you, and I'll get that for you.
Thank you.
Sorry.
Okay, Nikki.
Did Mr. Laurel have a criminal history?
So Mr. Lauro had been arrested once in 1987 for a shoplifting offense, which would have made him around 20 or 21 years old at the time. So that's the age, the period-specific photo that we released was his actual mugshot from that 1987 arrest. But aside from that, nothing.
Okay, 3 quick questions via Zoom from the Star Advertiser. What was told to Lauro about why he was asked to come in to talk to investigators?
So again, without getting into the details of the investigation and what was discussed, he was told, we did tell him why he was there.
Okay, second question is from Big Island Now. Where was Mr. Lauro's body found?
At his home.
And last question from the Hawaii Tribune Herald. You, Chief, are the coroner and are essentially ruling Lauro's death as a suicide. Has there been an autopsy, and what did the ME state?
So there is no medical examiner. There is no ME. The autopsy, whether or not the autopsy has been performed, the autopsy, there was a dissection autopsy that was performed. And based on that, based on the forensic evidence, that's why we've determined that the cause and manner of death is suicide.
Okay. Last round?
Was the call for service on the day the body was found, was that made by another resident, or who made the call for service?
You're talking about last week when we found Mr. Lauro's body? I believe it was from a family member who was worried about Mr. Lauro, but that's all I know. I'm sorry. We can find that out for you too, though.
And that concludes our press briefing. I want to thank you all for joining us today.